Welcome back. Gyanvapi Mosque survey row has now reached the court and the hearing in this matter has started in the Varanasi court. Remember, a plea has been filed from the mosque panel seeking the court to remove the advocate commissioner in this case. My colleague Pranchu Mishra is also joining us on this. Pranchu, several massive ramifications as far as this entire row is concerned, of course, but also from what is being contested today.
Yes, that's right. See, this is in fact the extension of that petition which was filed by Anjuman Intizamiya Committee, which actually manages the affairs of the Gyanvapi Mosque. And if you remember, on day one when we were reporting out to Varanasi, that is on 6th of May, when the survey started, immediately after that survey on the day one, the Intizamiya Committee has gone back to the same court saying that Advocate Commissioner, in this case Mr. Ajay Mishra, is acting in a biased way. He is not impartial and therefore fair investigation or fair survey or videography can't be conducted under his leadership. Please change the Advocate Commissioner. On which the court has accepted this petition, but it has, refused to stop the ongoing survey the next day. But it has said that on 9th of May, let Advocate Commissioner also make his stand clear on this petition because this petition makes serious allegations against him. So as this hearing starts today at 2 p.m., Advocate Commissioner will be going to present his statement. This hearing today is important because in case the court decides that since there is no agreement on the Advocate Commissioner, if it decides to change or replace the Advocate Commissioner, then the big question would be what happens of that 2.5 hours long survey report which was made and conducted on day one. The other point, of course, is which the Hindu side is saying that on day two, when the survey was stopped by the people inside the mosque, citing the fact that there was no clear-cut mention of survey being allowed inside the mosque. So Hindu side is going to pray that court should make very specific instruction that which are the areas in the disputed zone in which this survey can take place. So the Hindu side is going to pray to the court today that please mention specifically that the survey could be done under the Gyanvapi Mosque. So is the court also going to entertain it? We'll have to see, because the next crucial hearing in this matter is also, is also on 2nd. Tomorrow, I beg your pardon. And before that, the court is today going to decide that whether the same advocate commissioner will continue or he will be replaced.
All right, Pranchu, for that, we'll keep coming back to you for more. Shifting our attention to some more updates coming in, and this is also relating to a court hearing. Now, the hearing in Supreme Court on the CPM plea challenging the demolition drive in Shaheen Bagh has now started. Judge has asked what is the fundamental right violation under Article 32. Now remember, a similar petition was filed earlier when the demolition drive was carried out in Jahangirpuri. At that time, there was a 2-week stay that was ordered. There was, of course, a lot of heated drama on ground in that case, as has developed today as well. But the matter has for now in Shaheen Bagh been rested, because even though the MCD teams reached there, they did not really use the JCB or the bulldozer anywhere, and they have left the area. Let me also go across to my colleague Arunima, who's joining us with more as far as this hearing is concerned. Arunima.
The Solicitor General has accused the petitioners of misrepresenting facts in the Supreme Court. This accusation came when the bench asked the Solicitor General as to why notice is not given. That was the allegation made by the petitioner, that there was no notice given. Suddenly, the officials landed up, and the Supreme Court asked them that, why don't you follow the rule of law? And it also asked the petitioners that why have you not moved the High Court? If, this is a public interest litigation, there is no personal liberty issue here, because CPM is the petitioner, and then they argued that they are here because it's a matter of public interest. Right now, what the bench is indicating is that it is not really inclined towards passing any order or issuing any notice. They want the petitioners to move High Court, and the Solicitor General is also arguing that proper procedure of law was followed, that this was a routine exercise. And he's also taken objection to this plea or the ground taken by the petitioner that structures were brought down. What he said was that, normal table chairs and other, smaller extensions that people make to their property, which encroaches on the road, attempt was made to remove that. There was no structure, permanent structure that was brought down, something that the petitioners were alleging.
Yes, so there are some questions that the court is asking both sides, isn't it? I think the court is also trying to establish what exactly has been brought down and what is the right that has been violated that the petitioners are bringing to the court. On another side, I think the court is also asking the government side as to why they cannot carry out these drives as per law.
Yes, exactly what I recounted. That both sides have had to answer some questions before the Supreme Court. The Solicitor General had to defend the government's action or the MCD's action as to why notice was not given. Something that the petitioners have alleged. They said the Hawkers Association is also present there. The petitioners have had to justify in court as to why they should be entertained in the first place, because it's not a matter of their fundamental right. It's the CPM which has moved the court. They are the petitioner. They are in not any way the aggrieved party, to which the petitioner said that, we are here because this is a matter of public interest. Like I said, so far the observations from the bench seems to indicate that they are not wanting to get into this matter. They said that in Jahangirpuri we intervened because permanent structures were being brought down. We showed also to our viewers in Jahangirpuri how juice shops, proper concrete structure, first floor, second floor were brought down. So the Supreme Court said that there we intervened because there were permanent structures being brought down. Here, no such structure has been affected. The petitioners argued that structures have been brought down. The Solicitor General said that they have got their facts wrong.
Well, in fact, if you look at what transpired on ground, Arunima, and you were also there, Amanatullah Khan was on ground to claim that actually there are no illegal structures, the temporary ones that the MCD wanted to remove. So the question of removing or bringing down any structures doesn't come at all. In fact, of course, we've tracked that entire drive closely. So it's a little strange on what ground the petitioners are arguing that structures have been brought down today.
Yes, that's exactly what the Solicitor General is also pointing out, that you've got your facts wrong. There are no permanent structures which have been brought down. There were some objections raised by the municipality to extensions that have been made by shopkeepers. Like our colleagues Siddhant, Anshul and Nikhil have also been reporting, this area, you will see the shops here are, at a floor above the road. They're raised structures. So to reach their shops, they've constructed staircases over and above the permission that the MCD might have given them. They've made the, staircases a little ornate. They've ensured that those staircases, the area around that is also encroached upon. There are some encroachments outside shops where iron structures have been made out. MCD was objecting to those, and even without the use of bulldozer, because the locals, the MCD officials, and also the Delhi police came to a consensus, they decided that we will remove this on our own. And the bulldozer was not really required in Shaheen Bagh and Jasola, unlike what we saw in Northwest Delhi.
Yeah.
This is exactly what Solicitor General is pointing out to the court as well. But the petitioners are insisting that A, rule of law was not followed because there was no notice that was given. It was all hush-hush. Suddenly this drive began. B, they are saying that some structures have been damaged.
Yeah. Both obviously cannot be true. At one level, locals on the ground cannot claim that they've already willfully removed all encroachments, temporary encroachments that may be encroaching about in the footpath or on the road area. And then in court, the CPM petitioners are arguing that, the MCD has brought down those structures. Both possibly cannot be true. So there is, of course, a dissonance as far as these two lines are concerned. On the law issue, Arunima, the MCD maintains that as far as removal of these temporary encroachments, hawkers, etc. are concerned, they don't need to serve a notice.
That's the bone of contention, whether you have to serve or that matter was raised before you know, and the court has asked for an affidavit from MCD. That hearing will take place in a few hours, so the law is made clear. This is what MCD has, that they don't need to give notice for encroachment because they don't even know who the encroachers are. Something that of these do not agree with, but update as to what is happening. Court, like I was saying, the court bench is not really inclined. After they're saying have to strike a balance. Even in Jahangirpuri matter, we told Mr. Sibbal, who was representing petitioners, we can't pass orders against all encroachments. Then just we are not of all encroachments in the city. What the petitioners said is that please let other affected parties approach the court. Petitioners are the CPM. The court is really asking, why are you here? What the voting of court has been accepted? Why did you go to the High Court? That's what Justice Gyanvapi said. And to which the petitioners say that they do not hear it.
Arunima, just interrupting you for a brief minute, a very important observation has come in from Justice Rao. And he has said that we have not given license to anybody to come here to say, my house cannot be demolished, even if it is unauthorized. You cannot take shelter of that order. We cannot interfere. That too at the instance of political parties. I think in that one statement, really the entire episode has been encapsulated because the Supreme Court is very cognizant of the fact that they cannot give orders against encroachment drives per se, against encroachment, because that will of course set a very bad precedent. And here the justices are reminding the petitioners of that. One, you cannot take into account what happened as far as Jahangir Puri is concerned to say that in any kind of anti-encroachment drive, it cannot go on. It cannot be a legal shelter that even if your property is encroaching, it cannot be demolished by the authorities. Secondly, their court is also pointing out that this is not something we can do at the instance of political parties, at the interference of political parties, because that, of course, then also sets a very bad precedent. The court is also going on to say, don't take shelter under court's order just because we are showing interference. There cannot be such petitions in anticipation of action by political parties. Should we look at only demolitions in the country? Why cannot you approach the High Court? So there is another reprimand coming in that why do you come to the Supreme Court for all of these matters? Concerned High Courts can be approached. I think they broached that subject with the petitioners. The petitioners insist that the High Courts will not hear. There is something that they're saying, that they're expressing a concern that the High Courts will not hear. But that, of course, again cannot be taken as a legal precedent because that will be dangerous. So the court there reminding the petitioners that you cannot do this. And certainly the court cannot be looked upon to give legal shelter to encroachments against any drive. My colleague Siddhant is also tracking this. And Siddhant, you were there on ground. The court is, of course, striking a balance here. They don't want to set a precedent that at the instance of political parties, any and all encroachment drives will be stopped.
Well, that's absolutely right. Actually, last time what happened in the Jahangir Puri matter, in half an hour, Supreme Court ordered stay on the demolition drive, anti-encroachment drive, which was carried out. Now, this is perhaps the reason that this set of petitioners, this group of people, got hopes from that one order, and today again they moved to the Supreme Court. But Supreme Court came out heavily on these petitioners, and Justice Rao made it very clear that Supreme Court is the highest court in the country. They cannot entertain every single petition related to the encroachment drive, or for that matter, any encroachment drive being carried out anywhere across the country, because in fact he also said that the Jahangir Puri order was given because structures were being brought down, and that was just an interim stay which was granted at that point in time. But once the stay has been given, that does not mean that the petitioners will knock the doors of Supreme Court all the time whenever there is some anti-encroachment drive being carried out across the country. Also, Justice Rao has to say that Jahangir Puri order does not mean that the Supreme Court has ordered seizures of all sorts of anti-encroachment drives across the national capital. So it came out very heavily on the petitioners.
Yes, so I'm just interrupting you for a brief minute, because we're getting some more observations from the court. Now, Surendra Nath, who's the petitioner's counsel, is saying, please grant us a 2-day stay. But the Supreme Court is saying that you mentioned it tomorrow in High Court. They've requested Solicitor General not to do anything till tomorrow. The Solicitor General has said whatever had to be removed has been removed. They just want headlines like Supreme Court saves the area from demolition. That's an important statement coming in from the Solicitor General, who continues to harp on the fact that this is all political. Supreme Court has also gone on to say this is not done. Such removal of encroachments are routine exercise. If we have to look at these matters, then we will look at such cases only. So this is a big observation that is coming in. Basically, as Ashwini Dubey, advocate, also joins us, the court is saying, first of all, take these matters to the concerned High Court. They've given time till tomorrow to the petitioners to raise it with the concerned High Court.
Yes, that's one thing. And the second thing, see, the observation by the Supreme Court says that why you are not following the due procedure of law. And without following the due procedure of law, the provisions of Delhi Municipal Corporation Act, as per which the mandatory notice has to be given before removing any kind of encroachment, be it legal, illegal, or made on the government land. And then one. And the second, you treat it as a regular this encroachment demolition drive, but you have not followed the due procedure of law. Then the Solicitor General mentioned that, look, we are following the due procedure of law, and the Supreme Court said that who are you? About the CPIM, how are you agreeing? Because the first and foremost questions arise for filing of any petition seeking the constitutional remedy is the locus of the petition.
Yes. Ashwini Dubey, just hold on your thoughts. I'll come back to you. That hearing is now officially over. As I was mentioning earlier, there is no relief or stay that has been granted by the Supreme Court to the petitioners in this case. Like I was also mentioning earlier, what they've said is that they are free to approach the concerned High Court, but no stay or no order against the demolition drive has been given. We'll have to wait and see if the petitioners now move the High Court and what the High Court's view is going to be. Yes, Ashwini Dubey, continue. Important point that the court is raising today is that the court cannot stop all anti-encroachment drives in the country. Certainly not in the national capital. They are routine. We all know that encroachment exists. They've also said that nobody can come to the court saying that no, you cannot demolish my house even if it's illegal.
See, that's the basic question. Yeah, the Justice Rao, if you remember, in the previous petition filed by Jamaat-ul-Hind, seeking that, look, these houses are being removed without following the due procedure of law. Court said, look, due procedure of law has to be followed, which is mentioned, which is the statutory rule. Here also, the Solicitor General said they just want to create headlines that Supreme Court saved the area from demolition. But the Supreme Court said, look, we are not going to say this, but yes, we are hopeful that till tomorrow you are not going to carry out any drive until then get them approached to the Supreme Court. The basic and foremost question which arises here is the locus. What locus a political party?
No, I take your point, but my question is beyond that. Now, tomorrow, if somebody in Shaheen Bagh goes to the court, to the High Court in this case, and says that we want to stay on this drive, what does the statutory powers of the MCD say? Can they remove these encroachments, temporary structures on the road without notice or not? Because the MCD is saying that that's all we are doing.
See, the MCD is saying that we are following the procedure of law. We have identified these encroachments. After due identification, we are regularly removing it in accordance with the statutory provisions mentioned in Delhi Municipal Corporation Act and Commissioner's notice. Because the DMC Act says that the notice has to be issued by the Commissioner. So Commissioner's notice have been issued, and exactly what we have transpired from the newspaper reports and the media headlines that from last week onwards, the Shaheen Bagh and few other areas were mentioned. Even the Sarojini Nagar area where the encroachment was found, the notice was issued. So this is the case where DMC is making and stating that we are following all due procedure law. We are issuing the notice after that.
There is a slight confusion, Ashwini Dubey, as far as permanent structures and temporary structures are concerned. Because I myself have spoken to the MCD mayor, for example, in the Jahangirpuri case, and they were very categorical in saying that if there are permanent structures that are deemed to be illegal, those are served notices. But, you know, small shops, temporary structures on the footpath or encroaching upon space in front of shops, illegal constructions like temporary structures that the shopkeepers also made, they don't need to serve a notice for that.
For that, time to time, periodically, MCD carry out these kind of drives. In each and every area, MCD carry out these kind of drives wherever the encroachment on the footpath, public roads, pavements is found. So here it is the question of encouraging making houses over the government land.
Yes. Okay. We'll leave it at that. As far as permanent structures are concerned, certainly the MCD has to follow due process. But what about hawkers, those who make temporary structures on the footpath or on the road area? That's really the bone of contention, because the MCD, as has been proven by visuals, hasn't really demolished any of that in Shaheen Bagh today. In fact, no demolition took place in Shaheen Bagh today. So the court and the Solicitor General also pointed that out, that the petitioners in this case, the CPM, has got its facts wrong. No structures have been brought down